state in this honorable court.
Good afternoon. Appreciate council's flexibility. Our next case is Farm Bureau versus Hebert. I'll note that Justice Dietz is recused in this case, and we will hear from the appellant.
May it please the court. Chief Justice Newby and Associate Justices, I am Bill Lipscomb. I represent the plaintiff appellant, North Carolina Farm Bureau. The decision of the Court of Appeals majority in this case conflicts with the plain language of the legislature's definition of underinsured highway vehicle. Applying the plain language of the policy of the legislature's definition does not negate interpolicy stacking, as Hebert contends. As pointed out in my brief, there's three basic requirements for UIM or underinsured coverage. The claimant has to qualify as an insured person of the coverage. Second, the claimant insured has to be legally entitled to recover damages from the owner or operator of an underinsured highway vehicle. And third, all of the liability coverage has to be exhausted. And I guess I would like to reserve 10 minutes for rebuttal. This case involves the second requirement, and more precisely, whether Hebert's vehicle meets the statutory definition of underinsured highway vehicle for Hebert's claim under his policy. There's no dispute regarding the parent's policy. Those limits were paid. I'm not getting this slide to advance. I may need some assistance from. Okay. Well, it's. I apologize. This was supposed to. All right, so the definition of underinsured highway vehicle consists of three sentences in the first paragraph of subdivision B4 of 20-279.21. The first sentence is what our Court of Appeals has referred to as the general definition, and it was the only part of the definition that was enforced before the 2004 amendment. The 2004 amendment added two additional sentences. The general definition simply requires a comparison between all liability coverage from all potential policies, and you compare that to what I call the compared UIM coverage, which is written by the legislature as the applicable limits of underinsured motorist coverage for the vehicle involved in the accident and insured under the owner's policy. The underinsured coverage of Hebert's policy is the only UIM or underinsured coverage within the legislature's description of the compared UIM coverage, which is the applicable limits of underinsured coverage for the vehicle involved in the accident and insured under the owner's policy. The vehicles covered by the parent's policy were not involved in the accident. The general definition is not met because all the liability coverage is Hebert's 5100 policy, and that is not less than Hebert's 5100 of UIM coverage. Now, the Court of Appeals majority in this case relied on two previous Court of Appeals decisions in Farm Bureau versus Boston, Benton versus Hanford, for the conclusion that Hebert can first stack all potentially applicable underinsured coverages and then compare that stacked total to the liability coverage. And if Hebert can do that, clearly the definition is met because his 50 UIM plus the parent's 100 UIM clearly is 150 is greater than the 50,000 of liability coverage. But the Hebert's position and the Court of Appeals position in the two prior cases is that the inter-policy stacking provisions in the second paragraph of subdivision B4 allows the UIM coverage of the parent's policy to be treated as or considered as underinsured coverage for the vehicle involved in the accident and insured under the owner's policy. That position conflicts with the plain language of the general definition because the parent's policy does not provide coverage for the vehicle involved in the accident. None of the vehicles covered by the parent's policy were involved in the accident. This stack and then compare rule of Bost and Benton and the Court of Appeals majority in this case also conflicts with paragraph subdivision B1 of 20-279.21, which states that an owner's policy shall designate by explicit description all vehicles with respect to which coverage is thereby to be granted. Hebert's policy and the parent's policies are owner's policies because they designate by explicit description in the declarations pages the vehicles with respect to which coverage is thereby to be granted. Hebert's declaration pages begin at record page 7. The parents begin at record page 38. Subdivision B4 is a subparagraph of B, which states the requirements for an owner's policy. An owner's policy must designate all vehicles with respect to which coverage is granted and must provide liability coverage pursuant to subdivision B2, uninsured coverage pursuant to subdivision B3, and underinsured coverage pursuant to subdivision B4. The parent's policy designates 3 vehicles with respect to which coverage is granted. None of those vehicles were involved in the accident. The UIM coverage of the parent's policy does not fit within the legislature's description of compared UIM coverage for the vehicle involved in the accident and insured under the owner's policy. The owner's policy in the compared UIM coverage in the definition of underinsured highway vehicle is the policy that grants coverage with respect to the vehicle involved in the accident, which is Hebert's vehicle in this case. The rule, this stack and then compare rule of Bost and Benton essentially rewrites the general definition by changing the compared UIM coverage from the policy that covers the vehicle involved in the accident to all policies for which the claimant qualifies as an insured person. The second paragraph of B4, which Hebert relies on, does not change the general definition, which is that first sentence of the definition. And the general definition should not be controlled by the inter-policy stacking provisions in a separate paragraph. The inter-policy stacking sentence in the second paragraph explains how the amount of UIM coverage is calculated. The second paragraph begins, in any event, the limit of underinsured motorist coverage applicable to any claim. There cannot be a limit of coverage unless there is coverage. The 3 threshold requirements must be satisfied before the stacking and calculation provisions come into play. The second paragraph of B4, the stacking provisions, does not say that if a claimant like Hebert qualifies as an insured of 2 or more policies, the general definition is changed to allow the compared UIM coverage in the general definition to include all policies for which the claimant qualifies as an insured. instead of what the words say, the owner's policy on the vehicle involved in the accident.
So the Court of Appeals, in addition to relying on precedent, pointed to the avowed purpose of the Financial Responsibility Act and said that the act is to be, that it's remedial in nature and should be liberally construed in favor of compensating innocent victims. Do you agree that that's an interpretive principle that we should apply here? And if not, why?
I do not agree. I agree generally that that's a valid interpretive, but you don't employ that principle unless there is any ambiguity in the statute, where the plain language is clear and unambiguous. The court has a duty to apply the statute as written. So that's a valid interpretive principle. I don't think it applies in this case.
So we only turn to that when the language isn't clear, and we use it to resolve an ambiguity, and your argument is the language is clear, there is no ambiguity, and so therefore we don't consult the purposes of the act. We're bound by the language the legislature enacted. Right?
Would you repeat the question, please?
Well, it was kind of a long one, sorry.
Well, and I wear hearing aids, and so that's part of the problem.
If I understand you correctly, you're saying we don't resort to that interpretive principle of liberal construction unless the statutory language is ambiguous.
Right, correct.
If it's unambiguous, we have to follow it because that's what the legislature's told us.
Correct. That's correct. And now I'd like to shift gears to the 2004 amendment, which are the second and third sentences of this long definition. The first sentence of the amendment expands and broadens the general definition with a caveat. The first sentence of the amendment expands the definition by changing the compared liability coverage from the policy limit of liability coverage to the amount actually received by the claimant. The compared UIM coverage remains the same, using the exact same language as used in the general definition for the uninsured motorist coverage for the vehicle involved in the accident and insured under the owner's policy. The Hebert's vehicle clearly meets the expanded definition in the first sentence for his claim under both policies, because the $100 that he received from liability coverage is obviously less than the $50,000 of UIM coverage for the vehicle involved in the accident, his policy. But the caveat in the second sentence says that a vehicle cannot be underinsured for a claim under the policy insuring that vehicle unless that policy's UIM limits exceed that policy's liability coverage limits. The caveat applies to block Hebert's claim under his own policy only, because the claim is under the policy that insures the potential underinsured at-fault vehicle driven by Corbett. And Hebert's UIM limits are not greater than his liability coverage limits. Now, the caveat does not apply to Hebert's claim under the parent's policy, because that claim is not a claim under the policy that insures the potential underinsured at-fault vehicle. Applying the plain language of both definitions allows both definitions and the inner policy stacking provisions in the second paragraph to have operative effect, which is unlike Hebert's position, which Hebert's position simply does not allow the the compared UIM description to have any operative effect. But applying the plain language allows all provisions to have effect. In claims where the 2004 amendment does not apply, so that you're only dealing with the general definition, as long as the general definition is met by the tortfeasor's liability coverage being less than the UIM coverage for the vehicle involved in the accident, as long as that general definition is met, if the claimant is an insured person of additional policies, the claimant can stack all of those additional policies regardless of the limits. It doesn't matter what the limits are. The limits can be less than the limits in the tortfeasor's liability coverage because the general definition is met by comparing the liability coverage to the underinsured coverage for the vehicle involved in the accident. As long as that definition is met, if the claimant qualifies as an insured person of other policies, that the stacking is essentially unlimited. And then for claims like Hebert's, where there are multiple claimants, and you have to look at the 2004 amendment multiple claimant exception, if the expanded definition is met by comparing the amount actually received from liability coverage to the underinsured coverage for the vehicle involved in the accident, the only policy that's going to be blocked or foreclosed by the 2004 amendment is the policy that covers the at-fault vehicle. For claimants like Hebert, even though that, and that policy, that claim under the at-fault policy is going to be blocked only if that policy's UIM coverage limits are not greater than the liability coverage limits. But in cases like Hebert's, where his vehicle clearly meets the expanded definition, the caveat applies to block his claim because his UIM limits were not greater than his liability coverage limits, but any other policies that he qualifies as an insured of, he can stack those policies. So if Hebert had siblings that lived in the parent's household and all of those siblings had UIM coverage, he could stack all of those policies because the definition was met because his 100 is less than 50,000, and the caveat only blocks Hebert's claim under his own policy. So the plain language of the general definition allows all paragraphs of B4 to have operative effect. Now,
can I just ask to make this? I apologize if this is an obvious question, but are you arguing that if his car was included on his parents' policy, then he could collect because
if Hebert's car was a covered vehicle of the parents' policy,
right,
instead of on his own policy.
Well, or in addition to, could it be in addition to?
I don't think that anyone would want to have the same vehicle listed as a covered vehicle on two policies.
Okay.
But if his vehicle was on the parent's policy, okay, if his vehicle is on the parent's policy, all right, so the general definition, his vehicle was on the parent's policy. Okay, so that, I'd have to think, Frank, I would have to think about that one. I'm sorry. But the 2004, the majority in this case did not apply the caveat, and the Court of Appeals in this case really did not explain why the plain language of the caveat did not apply to block Hebert's claim. They simply relied on the Nationwide versus LeBay case, and the facts in LeBay were similar, but and you can see from the slide the facts, and I'm sure you're familiar with it, but the The vehicle in which the two claimants were passengers did meet the expanded definition of the amendment because the amount they received from liability coverage was less than the $50,000 per person limit of UIM coverage for the vehicle involved in the accident. The caveat should have applied because those claims sought coverage from the vehicle, from the policy that covered the alleged underinsured at-fault vehicle, and that policy's UIM limits were not greater than its liability coverage limits. The Court of Appeals does not really explain why, in LeBay, did not explain why the caveat did not apply. They simply relied on the liberal interpretation rule and said we're not going to apply the multiple claimant exception in a way that would reduce compensation to innocent victims. And I would like to say, well, and final point is that the dissent in this case says that LeBay is not controlling because the claimants in LeBay were not the owners of the at-fault vehicle like Hebert was, although that is a distinction. The caveat is not really limited to the owner of the alleged underinsured vehicle. The caveat applies to any claimant insured of the policy that covers the alleged underinsured vehicle. I'm going to reserve the rest of my time for rebuttal. Thank you.
Thank you. We'll hear from the appellee.
May it please the Court, Mr. Chief Justice, Associate Justices, my name is Preston Leslie, and I represent the appellee Matthew Hebert. Mr. Hebert bought and paid for UIM coverage above and beyond the state's mandatory minimum limits. The appellant accepted increased premiums in exchange for increased protection. Now, based on their interpretation of the statute, the appellant comes before you today asking this court to overturn nearly 30 years of precedent so that they do not have to uphold their end of the bargain. So despite the semantics and the complexity of the statute, this case boils down to one very simple issue. It is whether Mr. Hebert's vehicle is an underinsured vehicle under the statute. We all know it to be an underinsured vehicle using common sense. Clearly, there were more injuries than the coverage that was available. But we're asking whether the vehicle is an underinsured vehicle under the entire statute, not just one general paragraph. So there's no dispute that Mr. Hebert is an insured. There's no dispute that he's an insured under both his policy and his parents' policy. The only thing we're looking at here today is whether his vehicle is underinsured. So this case derives from an auto accident happened nearly 4 years ago. The briefs kind of brushed over it, and we've kind of brushed over it a little bit during the appellant's opening. But at the time, Mr. Hebert was riding as a passenger in his own vehicle. He was with 3 friends of his, and Mr. Corbett was the driver. Mr. Hicks was sitting in the front passenger seat, and Matthew, my client, Mr. Hebert, was sitting in the back with his best friend, Chase Hawley. They were heading towards Clayton. They were on a 2-lane road. Not sure what happened because the 2 front seat occupants passed away, but we do know that Mr. Corbett went left of center and had a pickup truck head on. Highway Patrol determined that the 2 front occupants likely died on impact, and the driver of that pickup truck is Mr. Coates. Both Chase and Matthew suffered severe injuries. I think it's important to talk about the injuries because unless the injuries justify the underinsured coverage, you never even get there. By some miracle, let's just say Mr. Hebert walked away unscathed, well, then we wouldn't be here today. But unfortunately, Mr. Hebert suffered a left femoral fracture, left ankle fracture, skull fracture, facial fractures, and a TBI. As a result of all of the treatment, he incurred over $270,000 in medical bills. which is clearly in excess of even the $150,000 that we're here asking the court to interpret under the Act. You can see here on the slide that the breakdown of the coverage is as follows. Mr. Hicks, he took a portion, or I should say the estate of Mr. Hicks took a portion of $49,500. Mr. Hawley also got $49,500. The Coates vehicle received $900 of liability coverage, and Mr. Hebert received $100 of liability coverage. Court may be asking itself, why did these folks only take $900 and $100? That's because they have underinsured motorist coverage protection, or at least Matthew thought he did to an extent. We do know that the Coates vehicle also had underinsured protection. That's the reason he took a smaller amount of the available liability proceeds. It's undisputed as well that Mr. Hebert, given his age, he was only 18 at the time, was a resident of his parents' household. His parents also had a Farm Bureau policy with a $100,000, $300,000 per accident policy of insurance with equal parts liability and UIM coverage. Farm Bureau paid the undisputed $99,900 in UIM coverage, $99,900 because they took a $100 credit, which is also found further down in B4, not just up at the top close to where the general definition is. It's worth mentioning today because there was some confusion early on in the briefs, but the appellant's position at the Court of Appeals was that the only reason Matthew recovered underinsured protection under his parents' policy was because his parents' policy met the definition of an underinsured vehicle. They kind of swapped horses there with their reply brief at the Court of Appeals and said, actually, that's not the case. The reason he received underinsured protection is because his parents' policy language was actually broader than the statute, so it had afforded him that protection. I believe the appellant just stated that he kind of went back to his initial brief at the Court of Appeals and said, actually, his vehicle is an underinsured vehicle under the parents' policy, given the language of the statute. So I wanted to point that out. But generally, we're talking about underinsured coverages and what is underinsured. This court has described underinsured coverage recently in the Dana case. I believe it was Justice Berger described it. Let's see. Passed to address circumstances where the tortfeasor has insurance, but his or her coverage is in an amount insufficient to compensate the injured party for his or her full damages. I would say that's a good definition. It meets what I would call the layperson definition. Of course, the legislature gets a little bit more wordy, and that's part of the reason we're here today. So you'll see 20-279.21B4. The appellant had pulled this up as well earlier, but it describes that an uninsured motor vehicle, an underinsured highway vehicle, includes an uninsured motor vehicle. So it expands on the definition of uninsured vehicle, in which the sum of limits of liability available under all bodily injury proceeds or liability proceeds at the time of the accident is less than the applicable limits of underinsured motorist coverage. So we've got this long-winded definition that the statute gives you, and it includes what the appellant calls the general definition, which is what they're staking their argument on here today. And then in 2004, the legislature had what they call the 2004 amendments. And I don't want to confuse, you may hear the term multiple claimant exception. That's different than the 2004 amendment. The 2004 amendments picked up where it says, for purposes of an underinsured motorist claim asserted by a person injured in an accident where more than one person is injured. The general definition, you do a direct-to-direct comparison of liability and UIM coverage. In your typical example, car A gets rear-ended by car B. Let's just say the person in car A has terrible injuries, $1 million in medical bills. The person in car B that rear-ended them has a minimum limits policy, 30-60, 30 per person, 60 per accident. The UIM coverage in car A is a 50-100 policy. So the available UIM coverage for car A would be $20,000 because the underinsured carrier for car A gets a $30,000 credit, so the available limits is $20,000. So they expanded that definition in 2004 because of an absurd result that was continuing to occur when you have folks with equal parts coverages. So let's just say car A has a passenger, innocent passenger, and they rear end car B, who has 2 occupants. They both share the same amount of coverage. They are both a 50-100 policy, a 50-100 policy. But because of the multiple claimants and the multiple payouts, each innocent claimant, whether it be in the tortfeasor's vehicle or the innocent vehicle that was rear-ended, receives less than the per-person liability limits. And that happened in a case called Ray versus Atlantic. It's mentioned in the briefs, and that's the reason the legislature, because they rarely go through and change the Financial Responsibility Act, but because of that case, the legislature went in and added what's called the 2004 Amendment and expanded and broadened that definition for coverage for that situation where there are multiple claimants, but because of the multiple payouts, they receive less than the full per-person liability limits. Now, earlier I mentioned the multiple claimant exception. There was a trade-off in 2004 at the legislature. They were going to broaden coverage for folks in those situations where there's multiple claimants, but the liability policy of the at-fault vehicle may match the UIM policy of the innocent vehicle. So they're going to broaden coverage, but in exchange for that, they were going to provide a protection for the carriers. And that protection applies in very limited circumstances. The only time that protection applies, the exception applies, the multiple claimant exception applies, would be in situations where, such as Hebert, let's just imagine Hebert did not have his parents' UIM coverage available. Well, in that very specific situation, and I believe it was Justice Behringer, maybe Justice Earls asked a pointed question earlier, what if, it was Justice Earls, what if Matthew's vehicle was only insured on his parents' policy and he didn't have his own policy? Well, that answer to that question is pretty simple. There'd be no UIM coverage available because of the multiple claimant exception. Those 4 occupants in that vehicle, if they didn't have any excess UIM, if they weren't living at home with mom and dad or had their own personal policy, well, then they'd be limited to whatever the liability limits were under that policy up to the per-person amounts. So no person can get more than the per-person amounts. So I want to make it clear, though. So the 2004 amendment is intended to allow claimants to access both their UIM coverage when the limits of liability coverage are greater than or equal to their UIM coverage, but the liability limits are reduced due to payouts to multiple claimants to a level that's less than the UIM limits. The second sentence of the 2004 amendment is what creates the exception. The first sentence is what broadens the general definition. And the second sentence must not be read in isolation. It has to be read in context with the first sentence. It's also important to note that nothing in, not quite yet. It's also important to note that nothing in the 2004 amendment was meant to limit stacking. The legislature did not touch paragraph 2 of B4. So if a passenger is injured while riding in a vehicle driven by a tortfeasor, there's nothing in the amendment that prevents the passenger from stacking the UIM coverage in the tortfeasor's vehicle, in this case Matthew's vehicle, with the applicable coverage that the injured passenger may qualify as an insured, for instance, like their parents' policy or a resident relative's policy. And then we need to look at the second paragraph, because the appellant is here asking you today to look at one paragraph of an entire statute which governs underinsured coverage. So the second paragraph is what we are looking at when we are determining what is the applicable, because I've heard that word before in other cases, but it's important here. What is the applicable amount of underinsured coverage as it applies to Mr. Hebert's situation? And based on the plain language of the statute, it's pretty clear to point out. So this paragraph, you can't quite tell in the slide, but it is immediately below the general definition, the 2004 amendment, and then it goes on to say, in any event. So that qualifies the series of definitions that came before it. It explicitly says, in any event, the limit of underinsured motorist coverage applicable to any claim, not just a claim, but any claim, is determined to be the difference between the amount paid to the claimant under the exhausted liability policy or policies applicable to the motor vehicle in the accident. And then it goes on to say furthermore. So it's adding on to that any event language. Furthermore, if a claimant is an insured under the underinsured motorist coverage on separate or additional policies, it's undisputed here that Matthew is an insured under his parents' policy. Furthermore, if the claimant is insured under the uninsured motorist coverage on separate or additional policies, the limit of underinsured motorist coverage applicable to the claimant is the difference between the amount paid to the claimant under the exhausted liability policies, aka $100 here in Mr. Hebert's situation, and the total limits of the claimant's underinsured motorist coverages as determined by combining the highest limit available under each policy. The legislature doesn't come straight out and say you stack and compare. That's verbiage from Benton, which is a Court of Appeals case, but we've been doing that for over 30 years, since 1992. We've always combined, compared, and given the credit. That's the way it's always been done. The stack and compare language didn't arise until 2009. The legislature doesn't say stack and compare. The legislature says combine and compare. Again, that's semantics, but it's essentially the same thing. And looking at the plain language of the statute, Mr. Hebert should clearly be able to avail himself of the full $150,000 in UIM coverage. So the appellant argues that Matthew's vehicle is not an underinsured vehicle based on their reading of the statute. This is a departure from their previous argument before this court in Farm Bureau versus Lunsford. In Lunsford, as you know, this court was interpreting the applicability of an out-of-state insurance contract where the claimant had a $50,000 UIM policy, which was issued in North Carolina. She was riding in the at-fault vehicle with her sister, and that at-fault vehicle was covered by a Tennessee policy, and they were both 50-100 policies. She got into a collision in Alabama, and she applied to have her UIM coverage under her own policy in North Carolina. The appellant in that case argued that the Tennessee policy was not applicable because it was issued in Tennessee, so therefore the North Carolina Financial Responsibility Act didn't apply, so therefore you can never even get to stack that coverage. I believe it was Justice Earls, actually I know it was because we're about to see a slide here, asked again a very pointed question. It's like, what if that policy, the Tennessee policy, had been issued in North Carolina? And my friend on the other side of the aisle gave essentially the exact same argument I'm giving you here today for coverage for the Hebert vehicle. So we're going to play that real quick.
Make sure I'm clear about what you just said in terms of you're not contesting Benton. So if I understand your argument right, you agreed that if the nationwide policy had been issued in North Carolina, then Benton would require stacking to determine if the car was an underinsured car.
That's exactly right. Exactly right. Yes.
And so then what about North Carolina's statute suggests that there should be a distinction when interpreting a North Carolina policy regarding which other state the other policy might be issued in?
Well, because the North Carolina statute says that you compare the liability coverage to all applicable underinsured coverage in order to determine whether the applicable underinsured coverage is greater than the liability coverage so that the vehicle can be considered underinsured.
Make sure I'm clear.
All right, so you heard that word applicable. That's exactly what paragraph 2 of B4 explains to what the applicable underinsured coverage should be for Mr. Hebert in this exact case. You take any policies in which he is an insured under, for instance, his own personal policy that he bargained for and paid increased premiums for, and you stack it, you combine it, with his parents' policy to come up with $150,000 in total UIM limits, and then you give the liability carrier the set-off, so then that leaves $149,900 in applicable UIM coverage. That is what the word applicable means. It's the applicable amount of coverage, which in this case is $149,900. Now, of course, we find Lunsford to be precedent case in this court. It was argued back in August of 21. You heard the appellant not argue with Benton. He didn't challenge Benton, or the appellant did not challenge Benton, I should say. They actually agreed that that was good law at the time. They could have challenged Benton at that point, but in fact they didn't. They were challenging the basis of it being a Tennessee policy. I'll remind the court that this case was, where this wreck occurred in 2020. That is when we should be deciphering the policy, so to speak, and applying the coverage. And the appellant was making the exact argument that we're making here today in August of 2021, after all of this occurred. So I've got a few examples just to walk through the court, because it's insurance law, your eyes can glaze over. But earlier, we talked about the general definition. So in a typical example, A hits B's vehicle and causes $270,000 in medical damages. Vehicle A has 30/60, that's what I spoke about with y'all earlier. B has a 50/100 policy. So if A's policy tenders, that's also important. If there's not an exhaustion of the liability coverage, you never get to the UIM coverage. So if A's policy tenders, aka it exhausts its coverage, then B then has $20,000 in available UIM coverage available. That's the easy part. That's the general definition, but then in 2004, they did the broadening of the general definition. So this is where it involves multiple claimants. For instance, A hits B's vehicle. A has one passenger. B has two passengers. Both vehicles have equal coverages. So both vehicles have 100, 300 in both liability and underinsured limits. A's policy tenders its liability coverage by paying out $98,000 to the passenger in its vehicle, and then leaving only $202,000 in available liability coverage. Since the total amount available to B and his occupants under A's liability coverage is less than the $300,000 that they have covering that vehicle, then based on the broadening of the statute under the 2004 amendment, B's vehicle can then tap into their own UIM coverage to make up the difference. Now, prior to 2004, they couldn't do that. That created an absurd result, and that's the reason the legislature broadened the coverage in 2004 with the first sentence. And that fact scenario there is the exact thing that happened in Ray versus Atlantic Casualty, where they had an innocent passenger in the tortfeasor's vehicle that took up $98,000 of the available liability proceeds. The Ray vehicle was this gentleman and his two daughters. I believe that was the facts of the case. And they could not avail themselves of the full policy they had purchased, the $300,000 in available coverage. The court said they were limited to just $202,000 because it was a direct-to-direct comparison. So the legislature saw that. They saw that they didn't agree with that result, and they wanted to change the law. Another example here with multiple claimants. Corbett negligently hits Coates' vehicle. Corbett has 3 passengers. Coates is alone in his vehicle. Both vehicles are covered by a 50/100 policy with equal parts liability limits. The Corbett passengers are not insured under any additional policies. So back to Justice Earle's question, what if Mr. Hebert was insured under his parents' policy? Or maybe let's just say Mr. Hebert was not insured at all. He wasn't living at home anymore, he was living by himself, and the only applicable policy was his own personal policy. Well, in this situation, the claimants can decide how they will split up the coverage, but for purposes of this example, the claimants in the Hebert vehicle will be limited to just the liability coverage. That's the multiple claimant exception. It creates a protection for the carrier so that the carrier is not paying out both liability and UIM limits unless it was bargained for. And to take it back to the beginning, Matthew bought and paid for excess UIM coverage when he purchased this policy way back in 2020. Now that doesn't affect the Coates vehicle. Coates, because he's in a separate vehicle, he's not in the at-fault vehicle, he can still avail himself of his own personal UIM coverage using that direct comparison that we had spoke about earlier. The multiple claimant exception is very narrow. It only occurs, or it only applies to claimants in the at-fault vehicle, and it only applies if claimants in the at-fault vehicle have no other applicable coverage. It's the only time the multiple claimant exception applies. So one last example. So Corbett negligently hits Coates. Everything's the same, except for in this instance, Matthew is insured under his parents' policy, which has 100 and 300 in limits. This is our scenario that we have here. The estate of Hicks takes $49.5. Mr. Hawley takes $49.5. They do not have other UIM coverage, so they got excess liability coverage. Mr. Coates took $900 because he made a claim under his own UIM policy. Mr. Hebert took $100 because he also has excess UIM coverage both under his personal policy, which is applicable, and his parents' policy. So the difference, and the reason we're here, is $149,900. That is the applicable amount of UIM coverage. So they've already paid out $99,900 under the parents' policy. So that leaves a $50,000 windfall to the appellant if you were to find in his favor, because that's the $50,000 in coverage that Matthew bought and paid for, that he is not getting the benefit of the bargain. Now, I took this demonstrative from my friend on the other side of the aisle, but his argument is essentially saying that if you find in Matthew's favor and Mr. Hebert's favor, you're essentially legislating from the bench. You're striking out all of that language there in green to find coverage for Mr. Hebert. But they're basing this interpretation on a narrow reading of the Financial Responsibility Act. We argue, or I should say the appellee argues, that you need to read the case, or I should say the Financial Responsibility Act in its entirety. If you were only to go down to the next paragraph, you would find the "in any event" language, which describes what underinsured coverage would be applicable. And it's also important to note that the legislature hasn't changed the law as it applies to stacking. The legislature has acquiesced, or the legislature has, in a sense, agreed that the judicial interpretation dating all the way back from '92 up until Benton in 2009, where you stack and compare, the legislature agrees with the judicial interpretation. The only thing they've done is expanded coverage. Getting back to the avowed purpose of the Financial Responsibility Act is to provide coverage for innocent motorists. That doesn't mean you need to find coverage in every nook and cranny, even where coverage doesn't exist. It's just asking the court to find coverage in situations where it was bargained for and it does exist. So,
Do you agree that we don't go to the avowed purpose unless we conclude that there's ambiguity?
I don't think I agree with that. The reason I say that is every statute has a purpose. So this statute is the Financial Responsibility Act. That doesn't mean that if one person has a little bit less insurance than the other, that they're a financially irresponsible motorist. The whole purpose of the act was to make sure folks that are driving on the road in North Carolina have at least some form of insurance. Now, it's been modified over the years to increase the premiums, but the theme or the theory behind that is to make sure folks are financially responsible, and in situations where they're not financially responsible, the avowed purpose of the act is to provide protection for folks who are financially irresponsible. For instance, folks riding around without insurance. So coverage in that particular situation. I agree and I disagree to an extent, but the statute is ambiguous. If you take out one paragraph and you look at it, for instance, the general definition, and you don't read any further into the statute, and then you jump down to paragraph 2 and it says in any event, you're thinking to yourself, what's going on here?
Yeah, so that's helpful because I was trying to figure out if you were saying, well, no, it's not ambiguous, it favors us, but it sounds like you're saying, yeah, there is ambiguity and therefore we look to the purpose.
Well, as as Judge Dietz, now Justice Dietz, mentioned in LeBay, it is ambiguous, and that's the reason that they found coverage in LeBay for that exact reason. But I want to point out here the green words that are highlighted on the appellant slide, and I'm running short on time, but he's essentially saying that we're asking the court to strike out this language. We're asking the court to legislate from the bench, essentially. Well, come January 2025, the legislature has spoken. Not sure if they caught wind of this case or they've caught wind of all the litigation surrounding this particular verbiage, but as of 2025, the new law in North Carolina expands the general definition to fit within what Mr. Hebert is claiming. So the total damages sustained by an individual seeking payment of benefits. So it's essentially saying, it's going back to the layperson definition of an underinsured motor vehicle in a nutshell. So in conclusion, as this court recently explained, the statute read in its entirety is open to more than one reasonable interpretation, and it is therefore ambiguous. The purpose of the statute is to provide protection for innocent victims. We're not asking the court to interpret the maximum possible recovery regardless of the facts and regardless of the situation. The appellee is only seeking what was bargained for when he purchased his policy. The law has always been stack and compare, been doing that for over a quarter of a century. It wasn't until 2009 when the stack and compare verbiage came about, but they always combined the coverage to compare prior to. In 2021, the appellant and Lunsford agreed that that was the law and did not challenge the same. The appellee respectfully requests this court to affirm the lower court in finding that Mr. Hebert is entitled to the coverage that he paid for. Thank you.
Thank you, counsel. Rebuttal.
I guess I'd like to first respond to the argument that because Farm Bureau did not contest the stack and then compare rule of Boston, Benton, and Lunsford, that somehow prevents Farm Bureau from challenging that rule now. But frankly, I represented Farm Bureau in Lunsford also, and I probably should have challenged it, but I had for many years just accepted the Court of Appeals decision in both Boston and Benton. And it wasn't until this court handed down its decision in Dana that a light bulb went off. And it went off because this court, Justice Irvin's opinion, stated that because of the length of this statute, we caution against placing too much emphasis on the plural or singular of the word limits in the statute. And he pointed out that when the legislature uses the singular of limit, they're referring to either the per person or the per accident limit, which is most insurance policies, yours and mine, we all have a per person and per accident limit of coverage. And when the legislature uses the plural, they're referring to both the per person and per accident limits of a policy. And Boston Benton really focused in the compared liability coverage. And I've got the wrong slide up there. Should be the next one. Yep. In the first sentence, in the general definition, the Boston Benton courts looked at the compared UIM coverage in green, the applicable limits, And they picked up on the plural of limits, that, well, since the legislature used the limits, the plural of limits, that must mean that you can also look to the inter-policy stacking provision, and therefore the UIM coverage of the parent's policy can be treated as UIM coverage for the vehicle involved in the accident. And when I read Dana, again, I just realized that that's a valid point here. And just because the word limits in the compared UIM coverage doesn't refer back over to the stacking provision in the second paragraph. What it's talking about is the per person and per accident limits of a particular policy, the policy that covers the vehicle involved in the accident and insured under the owner's policy. And in any event, that's why the law can't be that because an insurance company accepts a court of appeals decision and decides not to challenge it, that they're forever barred from doing that. It's the court's duty to enforce, to apply the statutes as the legislature has written them. This is the way the legislature drew it up. And it's not a narrow reading of the general definition. It's simply letting the definition speak, the applicable limits of underinsured coverage for the vehicle involved in the accident and insured under the owner's policy. And an owner's policy has to describe which vehicles coverage is being granted for. Hebert's position does, it essentially means that that phrase for the vehicle involved in the accident and insured under the owner's policy does not have any operative effect. It's the position that my client is arguing for that allows both definitions and the stacking provisions to have operative effect. As I've already explained, the position of applying the plain language of the policy does not prevent inter-policy stacking. As long as the definition is satisfied, you can stack. And going back to Justice Earle's questions, I finally figured it out. If Hebert's vehicle was covered under the parent's policy, but not his own policy, it would essentially be a reverse situation. You just have to work through the definition. If you're looking at the parent's policy, the general definition is not met because $100,000 of liability coverage, which is what, if Hebert's vehicle was covered under the parent's policy, there'd be $100,000 of liability coverage. That is the same as the UIM coverage of the parent's policy. So 100 equals 100, and the general definition is not met. And then, but the expanded definition from the amendment would be met, because $100 that he received from liability coverage is obviously less than the $100,000 of UIM coverage of the parent's policy. The caveat would block Hebert's claim under the parent's policy because the parent's policy covers the vehicle involved in the accident. But the caveat would not block Hebert's claim under his own policy. So Hebert would come out $50,000 worse if Hebert's vehicle was covered under the parent's policy. But he would not be able to access any UIM coverage from the parent's policy, but he would be able to access coverage from his own policy. And if he had siblings that were in the same household, he could also access all of their coverages and stack them.
Do you lose this case if we don't accept the plain language argument? Do you lose this case because of the liberal construction principle?
If you don't accept the plain language argument that I'm making, probably so. Yeah. But again, that's, our argument basically is that That is not ambiguous. That is not ambiguous. And it's especially not ambiguous when you look at it in context of paragraph B that sets out the requirements for an owner's policy. An owner's policy has to designate by explicit description or by appropriate reference all motor vehicles. You have to stick them, that's the framework, that's the language that the legislature has set out. And that's consistent with the language, with the compared UIM coverage that says UIM coverage for the vehicle involved in the accident and covered under the owner's policy. And the only other point I would make is just that the word applicable coverage means coverage that you can apply. And the only way you can apply coverage is if UIM coverage, if all three requirements are met. You have to be insured, you have to be legally entitled to recover from an underinsured highway vehicle, all liability coverage has to be exhausted. That's what applicable means, capable of being applied. If there's no further questions, I will sit down. Thank you.
Thank you, counsel. Mr. Clerk.